We can get started. We should probably get started.
Yeah, we have 1 minute until we get started. Hello, all. It's Paula Edgar, and I am the president of the Metropolitan Black Bar Association. And I am happy to have you joining us today for our webinar, which is called MBBA Learns Mediation, a Tool in the Dispute Resolution Tool Chest. We're going to have two wonderful panelists who are going to speak today about the process of mediation, give you some nuts and bolts, and you'll have the opportunity to ask questions. Speaking of questions, I wanted to make sure that everyone can hear me. So if you can, either use the part on the dashboard that allows you to do the raise hand option, so I can just see you all there, or type into the chat so I can confirm that you're all hearing me loud and clear. And I'll just wait till I see that. Okay, I see a couple hands. Great. Fantastic. All right, so prior to us getting started with the panelists, we are still waiting for one panelist to join us. I'm going to talk to you a little bit about the Metropolitan Black Bar Association and what we have upcoming, as well as some information about the organization generally. So let's get started. Oops, wrong screen. Okay, there we go. All right, so this is me. I'm the president of the organization. I have my own consultancy, and I am about 7 months into my my term as president. Hi, it's Jen. I'm giving an overview of the organization now, Jennifer, and then we're going to get started shortly with the actual conversation. So I'm talking to folks about the MBBA right now. So the Metropolitan Black Bar Association is a 33-year-old organization, and we are the largest black bar in the New York State area. And we do many things, including advocacy, as well as engagement around pipeline and other things that I will show you through. So today's panelists, briefly, are Alfreida Kinney, who's with the law offices of Alfreida B. Kinney. And then we also have Jennifer Lupo, who's with Lupo Law, Arbitration, and Mediation, PLLC. And they're both there on the screen. And back to what I was saying about the organization. So we have pipeline, professional development, presence, and partnerships, which are the 4 Ps of the organization in my term. It was important for me to have a focus on pipeline. Obviously, if we don't invest in our students in terms of sponsorships, scholarships, etc., we won't have folks to be a part of the profession going forward. So that was important to us to do. Professional development, such as today's webinar. We want to have a lot more opportunity for our members and supporters to engage with us in both online as well as in person. And then we've also had a big volunteerism push, which we call MBBA Gives. And we have done a backpack giveaway for elementary school students. We have done volunteering on both MLK Day weekend as well as on Thanksgiving, and we've done 2 community law days as well already. And then we have partnerships with different organizations in terms of the work that they're doing, and wanted to be supportive of those things and give our members the opportunity to learn about other organizations. At any point, feel free to ask a question about the organization. I'm happy to talk to you about that. So we need your help. Obviously, any membership organization needs folks to be engaged. These are the areas, both our sections and our committees, in which we have opportunity for you to be involved. In addition to this structure, we also have the opportunity for you to engage generally, to give us ideas, suggestions on topics we should cover, on other folks we should partner with and engage with. Sort of anything that you feel would be helpful to increase your engagement and to be supportive of the legal community generally, especially in terms of diversity and inclusion, and added to our numbers in the bar, it would be helpful. So if you haven't already become a member, we would like you to do that soon. Our next membership meeting is on March 23rd. It's going to be hosted by Sidley Austin, and information about becoming a member and going to our membership meeting will be on our website at mbbanyc.org. Upcoming events, we have our Masquerade Black Ball Affair, which is happening on this Friday at the Paper Factory Hotel. Next week, Tuesday, we have another webinar on student loan debt management. Then again, as I mentioned, the membership meeting on March 28th, we have our Women's History Month event, and our annual gala is on May 19th, and member tickets, the discount is up at the end of this month. So if you're going to get your ticket, and I know that you will, you should get that soon. And now, enough of me talking about the MBBA, although I can do that all the time. I would love to have our panelists, sorry, got you on there, to talk about mediation. And Jen, as you want me to, let me know who I'll do the polls as you asked me to, and we can start with both of you introducing yourselves.
I'm Alfreida.
The lead, Alfreida. Go ahead.
I'm Alfreida B. Kinney. I have my private practice in New York City. I serve as a mediator and arbitrator in various arenas. I do mediation primarily for the Southern District of New York and the Supreme Court Commercial Division. I do arbitrations primarily for FINRA, although I am on the panel of the AAA.
Hi, I'm Jennifer Lupo, and I'm the managing member of Lupo Law, Arbitration and Mediation. On the law side, we are a business law firm acting as outside general counsel to middle to small businesses, and mostly in the tech field. I am an arbitrator on the FINRA panel and onboarding currently to the commercial panel at the AAA. And I am on the Southern District panel as well as on a few commercial division panels for the Supreme Court. I've been a mediator for the past 12 years and an arbitrator for the last 2 years. I also have a private practice in mediation as well.
Wonderful. I think this would be a good time to find out from the people who are on the line a little bit about them. So I'm going to launch one of the polls, which is to find out what their current level of experience is. So you should all see a poll on your screen right now, which allows you to tap in and answer the question as to where you are within the legal profession in terms of your level of experience. Okay, good. So there's not any. I'll give you one more second. All right, so I'm going to close that. Okay, so you should see on the screen that we've got about 60% of the folks are 2 to 10 years out, and 40% are in the 10 to 20 range. So there's not any law students on the line, and folks have had a little experience. Okay. Now we can get to the next slide, which talks about what is mediation. Can you all see the slide? Hello? Jennifer?
I can see the slide, yes.
I can.
Okay, great. All right. Okay, so you both
okay.
There you go.
Yeah, we can see the slide. So, this is a great idea. This is a great overview of what mediation is intended to be. Really what mediation, to distinguish mediation from other forms of dispute resolution. Why don't we just lay out what they are? So, I mean, as the most common, it's litigation, and that is, driven by the circumstances of the court's, the judge's decision on whatever the claim is and whatever the prevailing law is with respect to the evidence that's provided. The parties and participants do not have much say with respect to how their matter is resolved. Akin to litigation is arbitration, and although it is handled outside of the judicial system, it is run in some ways in a quasi-judicial manner, in as much as the arbitrators will make the decision with respect to what the who wins, who loses, and with respect to the claims. What distinguishes mediation?
Jennifer, just non-appealable generally.
Right, and then with respect to mediation, mediation is driven specifically by the participants as opposed to counsel. It is a self-determined resolution of a dispute between participants, and it can be used in a variety of different types of claims. You can use it from family law, trust and estates, labor and employment, commercial and business, insurance. I mean, it can be used in any kind of way. And what's lovely about mediation is that it gives the participants an opportunity to have a say in the outcome. And what's great about that is that they help negotiate their own resolution through the use of a facilitative mediator to help them see the other side's position, see their own position, see the weaknesses and the strengths on both sides, and craft a resolution that they can live with. And in mediated resolutions, the percentage of folks that abide by their resolution is much higher than in other types of litigated or arbitrated type of resolutions.
So let me just jump in really quick right here to let the folks who are on the line know. If at any point you have a question, there is a question tab on the dashboard, so you can ask the question and I'll be able to let the panelists know what your question is, so feel free to use that. There's also a chat area, but you should use the question poll or question section so that we will know what your questions are. Jen, would you like me to ask if if anyone has participated?
Yeah, that would be great if you could do that poll to see where we are with in terms of that.
And while you're doing that, may I expand upon what Jennifer said?
Yes, go ahead.
First of all, more and more different types of cases are being mediated, including personal injury cases, which may be surprising to some, but there are quite a number of personal injury cases that are being mediated. What's great about mediation, particularly if you're dealing with people who have an ongoing relationship, like business partnerships or corporations who do business with each other, is that you can really craft your resolution to fit your issues. So if you were in litigation, you are bound by your pleadings. The judge is bound by your pleadings. And whatever you ask for as a remedy is what you are limited by. But in mediation, you have no such limitations. You can be creative, and you can work out, negotiate the most creative result that will work for an ongoing business relationship. That is, I think, one of the most important things about mediation is the flexibility that it awards and provides to the parties.
And you know, going a little bit further on that, when you have, I'll give you an area that I mediate a lot in is software development and information technology types of matters. And oftentimes companies enter into agreements with a software development company to provide a significant piece of software or a system process for their business, and it's a tremendous outlay for the business. We're talking millions and millions and millions of dollar contracts. And when something goes awry and you're $2.5 million into a $5 million transaction, it's kind of hard to pivot and go and get another provider and start again from scratch. So, sometimes they just need a hand in kind of coming off of their positions, because people get hot and fight with each other, and come up with a resolution where they can continue the relationship and not burn the bridge. And that's a wonderful thing that we can do, and as mediators, is we can help not only facilitate a resolution, but also help transform a relationship that may have come off the rails. So I see from the poll that a fair amount of folks have mediated before, which is great. And what's lovely about the opportunity, go ahead.
I was just going to say, I just launched the other one to see what practice areas our folks are from as well.
Okay, that's perfect.
Okay. Go ahead. I'm sorry. I'll show you the poll results now.
So,
here it is.
Okay, let's see. Okay,
so,
that's interesting. That's an interesting demographic, that there's a fair amount of folks that are government and non-for-profits. The government is, if you're in law department in the city, that most everything that litigates at some point, unless it's criminal, ends up in mediation in one way or another. If you're in federal court, or and so there's a lot of very seasoned practitioners that we've come across in civil rights litigation from law department that are folks that, if anyone on the line is in law department and is interested more in perhaps getting involved in mediation, they should seek out their colleagues to discuss with them, what experiences that they've had, and find a way within their offices to get into matters that would afford them an opportunity to mediate more.
Let me just talk about solo practitioners, which I happen to be one of. You probably know that litigation has become so expensive, so much money is involved, that your clients, who may be middle-class clients, cannot vindicate their rights because they just don't have the money to do it. They may be right, but they will never see the justice that they would like. I find that mediation is an economical way to help the client. The client will not pay as much in legal fees, and the client will thank you for that and come back to you again and again. But you will help the client not only to save money, but as I was talking about before, to create the resolution that really works for the client. So when you're representing clients who say, oh, it's a principle, I want to litigate, stop your client and say, let's talk a little bit about mediation. Let me explain to you what mediation is about. And you explain as thoroughly as you can, and see if your client will consider trying mediation before all-out litigation.
And that's a good point, Alfreida. I'm finding in my private mediation practice more and more that I'm getting, and from small non-insured entities to, larger companies that have insurance, that they are considering mediation prior to litigation as an opportunity to sometimes just narrow down the issues that they may have to litigate. Some things may have to litigate. But oftentimes we can resolve the entire matter in mediation as long as the practitioner is able to explain to their clients the benefit of mediation, and to also work with their opposing counsel in a meaningful way, because litigation, counsel's stance in litigation looks a lot different than counsel's stance in mediation, and that is something that's very important, that it's hard sometimes for the litigator to change hats when their client, where they perceive that their client is looking for a warrior. You can be a warrior in mediation and still be true to what the mediation process is, provided that you think creatively as an advocate and your opposing counsel does as well.
I agree 100%.
Thank you, Alfreida. So why don't we run through what the key qualities of mediation? The key quality of the mediation process is that it's voluntary. It is everybody who walks into that room wants to be there to resolve their dispute.
Let me just stop you here, Jennifer.
Go ahead.
Except for
court-ordered.
Court-ordered, right.
Except for court-ordered mediation, which is kind of an oxymoron. But if you have a good mediator who's helpful in, kind of getting you past the idea that sometimes the attorneys are disappointed that the matter has been sent out to mediation. So once you've done the work with the attorneys as a mediator and then start to, in your pre-mediation work, working with their clients and working with them, you could still have a voluntary mediated process, provided that you have a seasoned mediator that recognizes that, in particularly in court-ordered mediations, there's a lot of pre-mediation work that is a little bit different than the pre-mediation work that we do in voluntary private matters.
Right.
So that is the caveat between the two. It's collaborative. Everybody kind of gets in the room, and you as a mediator, we are facilitative. We're there to provide a safe environment for folks to have a conversation in a productive way to help them find and craft a solution that they can live with. Go ahead.
That's really important because some people may have experienced what quote-unquote settlement conferences with judges. True mediation is nowhere similar to what you have experienced as a settlement conference. The mediator,
100%.
The mediator
100% correct, Alfreida.
The mediator makes clear it is the process of the parties. It is not the process of the mediator. So the parties determine how things will go, not the mediator. The mediator guides the process, but is not the determining factor. Sorry, Jennifer, to interrupt.
I know, and to your point about the distinction between mediation and a settlement conference with either the judge or the judge's law secretary, is that ultimately, when you're having a judicial settlement conference, it is just that, a judicial settlement conference. It is a judge or a law secretary telling why don't you split the baby in half? Why don't you put more money on it? We don't do that as mediators. What we do say is, perhaps we want to look in ranges. Perhaps we want to, you might want to consider. But ultimately, it comes down to whether or not the party is amenable to doing so. We will cajole along the way because we actually know, with experience, where things probably should settle. If the participants are truly there for the right purpose. But yes, it is very different than a settlement conference, and that is the mistake oftentimes that you may find where you'll have a law secretary, and I hope I'm not offending anyone who's on the line, who might believe that what they do and what we do are the same thing. They are very different. Because the law secretary has the imprimatur of the judge. We mediators do not, and we also have no skin in the game to resolve the matter. It's up to the parties. That's who has the skin in the game to resolve their dispute. The court has skin in the game to move their calendar. Okay, so we did call collaborative. Self-directed. Mediations typically have a form and a format. They begin with opening statements from the mediator as well as the other, as each side. After the opening
I want to
statement.
interrupt, Jennifer. That depends
Right.
on the mediator, because I try not to make a long opening statement, because I would have done a lot with counsel, but I do make an opening statement only to the parties, really, not to the counsel. And my opening statement is not about anything that I know about the case other than to let them know, so we'll have some comfort level that I have read everything.
Right.
But
I mean, it depends on the mediator. I mean,
right.
typically, why don't we back it up? When we get when a matter comes into my office, whether it is court ordered or it's a private mediation, I mean, the first thing that happens is we do a scheduling call.
Right.
That's both attorneys on the phone, and I go through, you know, what I gauge what type of experience that counsel has with respect to the mediation process. I provide them with a document that I've prepared that explains the mediation process and at least the mediation process that they should expect when they come into my room as a mediator. And then we schedule the mediation dates. I ask for one whole day and then a second control day in case we go over time. And another thing that I run through is what I expect in terms of mediation statements, in terms of form, in terms of content, and in terms of length. What I'm looking for in terms of exhibits, what I'm looking for in terms of case law cited, and I lay that out, and I'm very clear with what I expect. I follow that up with an email to the attorneys, memorializing what that happened in that conversation, and then we schedule within a week or two after that first call, a confidential pre-mediation call between myself and counsel for each side, and they basically give me the skinny of what they see is going on in their matter, and then we schedule another call between myself and the counsel and their decision maker, whoever it is that's coming to the table that has the authority to resolve the dispute. And then we again delve even further into the situation, the facts, the circumstances, and get some more color commentary with respect to why this dispute has come across my desk, and you know what their thoughts are on resolution. And then ultimately, I'll get the mediation statements, and then I will speak a final time before we go in the room with counsel and their client to see where we are in terms of resolving the dispute. I encourage the attorneys to continue speaking with each other, and also if they want to use me before we even get in the room to start facilitating that conversation to, you know, resolve the case. And that's what I do in my pre-mediation work. You can't really walk in the room cold on the day of the mediation without having had some sort of pre-mediation conversations with counsel at the very least to build a rapport, because it's real hard to get somebody to build that rapport the day of the mediation.
Let me just stop you for just a second. Hold on one second. So there was someone who had a hand raised in the attendee list. Rather than do the hand raising function, why don't you, if you have a question, please add it to the questions section where you can type the question in there, and I'll relay it to the panelists. So anyone on the line, if you have a question, please let us know at that point. And that's it. Continue on, ladies.
So what Jennifer was describing was a pre-mediation conference, and you should know that every mediator handles a pre-mediation telephone conference differently, and the mediator may handle it differently depending upon how the case came to the mediator, whether it came as a court assignment or whether it is a private mediation, and also whether or not the mediator is aware of whether the attorneys and parties are interested in mediation as opposed to feeling that they are compelled to mediate. Let me just say something too. The discussion also during the pre-mediation conference to educate the mediator will include what discovery has occurred. What discovery do you want to occur? How can we possibly limit the discovery that you want? Have you had any disagreements about discovery? Can we resolve any of those disagreements now? With regard to the mediation statement that Jennifer referred to, that's an extremely important document, and counsel should not just slap it together. So, for example, let me give you an example of something that happened to me just a couple of weeks ago with respect to a pre-mediation statement that you will not do. And that is, you will not present a pre-mediation statement that almost repeats what you had in your complaint. The mediator has read the complaint. The mediator doesn't need to read it again. What the mediator needs to know is, where is the give and take for your client? Where, if you don't want to put a number on it, fine. Where might your client be willing to give a little bit, to compromise a little bit? What would your client like to see come out of the mediation? Does your client want to be reinstated in the job or not? Does your client just want monetary damages, or does your client want an apology? These are all things that are important in a mediation statement that the mediator should be aware of to the extent possible before the mediator walks into the session. I generally am aware of these things, even if the counsel, unfortunately, regurgitates the complaint. I try to take the time to...
Alfreida?
Yes.
Okay.
Can you hear me?
I can hear you.
Okay.
Your head around when you're talking. Try to like stay focus on the sort of same place with the computer, because I think it cuts out when you move your head around.
Oh, okay.
I'm hoping
Thanks
that's
for
what
letting
it
me
is. But go ahead, continue.
So I just wanted to let you know how important the mediation statement is, and that you should consult with your clients to make sure that you understand what your clients really want, because it may not just be money. It may be an apology or something else.
That is a very good point. I've had people hug each other at the end of commercial mediations. I've had apologies been done at the end of employment mediations. It's all different things, but it's really the practitioner's responsibility to prepare their client, and in a different way than you would prepare your client for a deposition. I mean, sometimes that's something that we say, Alfreida, I don't know if you agree, but there's been, sometimes I see attorneys that don't put the time or effort in, and they just think it's like preparing. They can do one bite of the apple and kill two birds by preparing them as if it's a deposition, and that's not helpful. This is not a Q&A. This is actually an A. Now, did I lose you folks?
Should I stick with this slide, or should I keep going?
You can go. Okay, so once we get into the room, we've talked about pre-mediation, and as Alfreida says, each mediator does things differently. To her point about the mediator's opening statement, I too do not speak. I have the parties sit next to me, and I have counsel sit further away. I ask for, it's very conversational. When I do my opening statement, I explain, again and again, because I keep hitting this point home, that I have no skin in the game. You can't spin me. And why would you want to? Because I'm not making a decision here. I'm the voice of reason. I'm also devil's advocate, and that's what my role is. And if you think I'm being hard on you, just know that I'm being equally as hard as on the other side. That's what my opening statements tend to be like. And then also, they get customized based upon, the pre-mediation work that we do, because there are some instances where you might have a complicated one counsel is a certain type of personality, other counsel isn't. You kind of, not that you want to work around the attorneys, but you want to make sure that the clients understand that it's their process, and if at any time they need to discuss something with you, they can discuss it with you if they want to do that confidentially, they want to do it with their attorney or otherwise, that's their choice. So that's, opening statements. And then from there, each side does an opening statement. One thing that I caution the attorneys and the parties, and in particular when you do commercial mediation and you get very sophisticated people in the room from like the business people or general counsel, is to not do a trial opening, because that basically sets a very bad tone for the rest of the process, and and you have to, as a mediator, work off of that and kind of, do a lot of reparative work to get it more into the conversational style. So, just a conversation. You may not agree with what the other party is saying at that time, but at least have the respect to listen to them and understand that that's their position and those are the issues that they see and that have brought you here today. And they give you the same courtesy when you do your opening statement. And then we can work from there. And but I'm very big on courtesy.
Me too. It has to be paramount. I just want to stress something that Jennifer said. Actually, during my pre-mediation conference, I tell counsel that I really am not so interested in anything that they have to say at the mediation in terms of opening statement, that I really am more interested in what their clients have to say. And because it's a process that the parties determine, I do ask counsel whether or not they want their clients to give a statement. Most attorneys will say yes. I've had a few who say no. And I want the attorney to know that in advance, because I say this will give you an opportunity to prepare your client for the statement that he or she will give, and also to prepare your client for what he or she will hear. And I tell them this is an opportunity for your client to talk directly to the other party. This is an opportunity for your client, without all of the legalese, to tell the other party how your client views the situation, why your client views the situation the way he or she does, how your client felt emotionally damaged or hurt. It's an opportunity for the other side to hear what the client is saying, and vice versa. So it's an opportunity, because the clients probably have not spoken since a little before the dispute arose. So this is an opportunity for them to, whether they agree with what the person is saying, but it's an opportunity for them to hear it. Then when the attorneys speak, it's an opportunity for, let's say, the client, for the plaintiff to hear what plaintiff's counsel is saying, which says it sounds good, but then plaintiff is going to hear what defendant's counsel is saying and say, oh, I've got some weaknesses in my case. The plaintiff may never have heard before walking into the mediation that there were weaknesses in the plaintiff's case. And so this is an opportunity for the parties to be educated.
That is for sure. It's like telephone. If what the client hears is distilled through the advocate's voice box, and the advocate is going to sometimes tell the client only what they perceive the client wants to hear. And it's very interesting to see those light bulbs go off during the opening statements, when one side looks at the other side and goes, never thought of that. That's when you know, as a mediator, that there's some room to start moving and start doing some good work. So, do you want to talk, Alfreida, a bit? Should we talk about the caucus and how caucus works?
Okay. Again, every mediator handles this differently. So, generally speaking, unless it's an unusual circumstance, and I have heard of unusual circumstances, but generally speaking, everybody starts off in the same room. The mediator with the counsel for both sides and their respective clients. I happen to be one, we call that a joint session. I stay in joint session a lot. There are some mediators who prefer to do what they call more caucusing. And caucusing means that the mediator is meeting with one side at a time. So the mediator may meet with the plaintiff and the plaintiff's counsel to obtain information. Now, I want you to understand the mediator can only do the mediator's job if the parties give the mediator information. So a lot of that time in the caucus is spent by the mediator asking questions. And then as you get further along, the mediator may offer his or her opinion. So, and the mediator says to the people during the caucus, tell me what you think is important to me, but what you tell me will be held in confidence unless you tell me I can disclose it when I go next door and talk to the defendant's counsel and the defendant. So the caucus what happens in the caucus is usually information gathered is usually held in confidence until the mediator is released and told that the mediator can tell the other side what's said. But as I said, some people spend almost the whole time in caucus. I try to spend less time in caucus because I think it's important for people to talk to each other across the table. Jennifer, you want to add to that?
For me, it depends on the type of transaction it is and also the personalities that are involved. But I have people in joint sessions for a bit, and then I do caucus, and then I'll bring them back into joint session because at some point in time, the resolution of the matter really comes down to the business people talking to each other in commercial matters. But again, it depends on the type of mediation that it is. For commercial matters, yes, a joint session can work very well. For other types of matters that might be a little bit more emotionally charged, sometimes it's necessary to give people a break and separate rooms to, kind of process the information that they have heard in joint session, or also just to vent in a meaningful way and not have them vent on the other side. Again, it depends. Trust in estates. When I do trust in estate matters, sometimes, it's a bunch of family members that are right at each other's throats over a lot of money, and it's probably not in the best interest to leave everybody in the room. And other ones, in commercial transactions, I find that folks stay in joint session a lot more than they do in, the T&E or sometimes even labor and employment.
Also,
it depends.
Also, in a caucus session, it's an opportunity for the client to ask questions of the mediator or to express him or herself in the presence of counsel. Because I hear as a mediator a lot of discussion with counsel, which ultimately helps me as a mediator to hear what the client is saying to his counsel, what the client is asking counsel.
And it's also the opportunity to see not the misinformation that counsel has given their client, but oftentimes, sometimes it's misinformation. Sometimes it's, it's conspiracy theory almost. They're doing this and they're doing that, and starting to peel that onion back to get it, and why do you feel that this way, and what have you, and sort of kind of like debunking. Because remember, the participant, the party, an interest, has hired their lawyer for a reason, right? And you don't want to undermine the lawyer too much because they're relying on their lawyer. But on the other side of the coin, if the lawyer's in the way, you kind of have to help the lawyer get out of the way so that the matter can resolve.
Also, a different point, the caucus sometimes is used for the mediator to help counsel. Sometimes counsel cannot convince his or her client or something, or the client doesn't believe counsel, or the client is just being difficult. And counsel may have asked the mediator, would you discuss X with my client and explain to my client what the advantages and the disadvantages are. So sometimes counsel uses the mediator to talk to the client when counsel can't, and that oftentimes can help result in a mediated settlement.
Absolutely. Absolutely. And that's something that in my pre-mediation work, and I don't know if you do it, Alfreida, but that's part of my color commentary, is I want to know about the relationship between counsel and opposing counsel, and I also want to know about the relationship between counsel and their client. I want to know about the client's personality, how did we come to this situation, why are they in this litigation, what's their feelings about the litigation, what positions are they, are they, I'm going to litigate this for principal kind of folks, or what have you. Those are the types of things. And sometimes you'll get a call from an attorney that'll say, I'm going to really need you to help me move my client. I've been telling my client X, and my client just cannot accept it, and I really need your help with that. And that's great. So going into the mediation, what part of what your tasks are going to be for that day.
Right. We should probably move on.
And then things happen that you don't expect, always. And just be prepared for that. Expect the unexpected is what I say.
Right.
So, do we want to see if there are any questions from the audience to see if there's at this point?
If they want us to talk about something particular.
There's not any questions right now in the pane,
okay.
But audience members, as you're listening right now, if you have any questions about what's been said already, or if you have particular questions about the process of mediation, feel free to use the question pane right now, and I'll relay any questions that you submit to the panelists as you submit them. Until then, we can just keep forward, and I'll just stop you guys.
Now, Alfreida, perhaps now is the time for us to discuss, how to make a career in mediation.
Well, I have a question right now. So the question says...
Well, why don't we answer the question first?
It might be the same thing. So if you are new to mediation, how do you become a mediator arbitrator?
Okay, so it's exactly where we were going.
Nice segue. Thank you very much.
Yes. So first, let me just start off by saying it is not an easy task. Okay, either way, mediator or arbitrator. However, you have to recognize what the market is. So if you are a litigator, you have an advantage, in my opinion, of becoming an arbitrator, particularly in commercial cases, because the corporations or the clients of AAA, when they are looking for arbitrators, they are looking for people who understand litigation and people who may have people who know the law in that particular substantive area. This is extremely important in arbitration because you cannot appeal an arbitrator's decision as you can a judge's decision. The only way you can appeal an arbitrator's decision is if the arbitrator failed to disclose some conflict of interest or totally ignored the law. And that's pretty hard.
Manifest injustice.
Manifest, right. Say it again, Jennifer, manifest disregard, right?
Injustice.
And disregard for the law, which is pretty hard to demonstrate. So because it's not appealable, those people, the general counsel, in-house counsel at corporations, tend to go back to the same old people. So it is hard to break in. So how do you break in? If you are in a law firm, but I didn't see anybody here in a law firm except for solos, then you would go to your, discuss this with the partners and senior counsel, see what you can do. But we don't have those people on this call as I understand it. So the people who are solos and the people who are in not-for-profits, unless you have a specialized area, I would put my emphasis on mediation. Jennifer might disagree with this, but I would really put my emphasis.
No, I agree. I agree that at least, I agree with you, Alfreida. I mean, that's how I ended up becoming an arbitrator. It was because I got more exposure as a mediator, and I have subject matter expertise in information technology, and that's it. I mean, it's just the exposure that gets you get your mediation. You learn the craft of dispute resolution in the mediation sector, and then you work your way into being parts of bar committees. I mean, Alfreida and I sit on the State Bar Executive Committee for dispute resolution. We both chair committees. It's a matter of getting yourself out there and promoting, getting to know people, getting to know the players in the field, and that's where you get the invitations then to go into other areas, and that's how I went into arbitration from that. But that's it.
Bar. Don't forget we were both on the City Bar as well.
Oh, I forgot. Sorry. Yes, we're on City Bar as well. Right in the area. You have if you're an attorney with first thing, many of the panels require a certain amount of years of legal experience and then a certain amount of years of mediation experience. So first thing I would say is for folks who are interested in becoming mediators, find out what the local panel's requirements are. They're published. So the Southern District has theirs on their website. The Eastern District as well has theirs. The Commercial Division has theirs for the various counties, and find out what the rules are. And then from there, go to the trainings. There's a training coming up next month from State Bar at Fordham. It's, I believe, the 14th, 15th, and 16th of March is the basic commercial mediation training. Then there's going to be a basic commercial arbitration training in June, also State Bar. Most of the mediation trainings, what I would say to the participants on this call is be mindful of where you do your training. Your training, it has to be a legitimate organization. So the bar associations tend to be the best places for you to get that type of experience, that type of training. The folks who provide the training, the trainers for the bar associations have been doing it for many, many years, and they meet the curriculum meets the requirements to get you what you need to know so that you can continue in advance. There's a lot of mediation.
Let me just add.
Continue.
Let me just add. You might also want to consider what's called the Peace Institute that was formerly Horizon.
Correct.
Particularly dealing with family disputes. I understand from my colleagues who do trust estates and domestic relations that the training that they got from the Peace Institute was great. You may have to do a lot of pro bono work, a lot of pro bono work before you begin to be paid for your services, because you have to build up your resume and your experience and your skills.
So we've had two other questions, but I think that your correspondence is addressing them. I'll just tell you what they are just so that you know. The other question was about, would you open to speaking about entering into the profession, where and how do you get experience, which you just started talking about. And the other one is, can you address mediator selection? So.
How to pick a mediator. Well, how about this one? I'll give you not only how to select one, where to find one that's not at JAMS or AAA. How's that?
Thank you.
There's a whole bunch of us out here that are excellent at what we do, and we tend to be on the court panels, just like our colleagues that are at AAA and JAMS. And I mean, Alfreida's at AAA. I will be at AAA shortly, and this is not a poo-poo to AAA, but there is a fee that you would have to pay to the organizations. Say it again?
It's not cheap.
And it is not cheap. At all. So what on the Commercial Division website for ADR has all of the Commercial Division mediators for New York County that are on the panel. The same for Southern District, and it lays out what folks their academic credentials. It lays out their years of experience in mediation. It lays out the areas in which they mediate. It lays out, what kind of practice, if they're also practicing attorneys, what areas of practice that they're in, and contact information. That's one way to do it. And then that's it. I mean, most of us know each other. It's not a big pond. We all pretty much know each other that do commercial mediation.
And let's be full disclosure here. You may get on the panel of AAA because you certainly have the experience in a number of years, but that does not guarantee that you will be assigned cases, because
Correct.
it is still, quote unquote, the old white boys network.
It's very difficult for people, and women too, for women and people of color.
That's why I said what I did, because women of all colors have a difficult time being selected. So you need to be aware of the realities that continue and to do something that will try to make yourself stand out, particularly if you have a specialty in an area: copyright, trademark, construction, labor, employment. Those are really important things.
That's a perfect transition to the next. There's a comment which says that junior attorneys volunteering as a pro bono mediation counsel is a way to get into the profession. And I think that because one of the reasons why we decided to start to talk more about ADR and mediation and have the bar, the MBBA as a venue, is because there's a lack of diversity in terms in this area, and we really want to encourage more people to consider this as something in terms of a supplement to their career path or as an alternate career path. And so we have 4 minutes left for the webinar. I'm encouraging folks, if they have other questions, to add them in there now. But the conversation about diversity in terms of gender as well as racial and ethnic is important.
It's the same. The predicament in terms of diverse persons having an opportunity to be mediators or arbitrators, or being selected to be mediators and arbitrators, is no different than the same problem with folks getting hired in law firms. With that said, there's a two-prong approach. One is, folks need to stay in law firms, and people of color need to stay in law firms and make partner. I say this to my colleagues all the time that are on the fence and saying, I don't know if I'm going to stay or not. It's like, if you feel like you can make partner, you have an honest conversation with your firm. If you're not on track, then definitely leave. But if you are on track, why not? Because until we fill the upper echelons, not fill it, but at least sit in them, it's very hard to get hired. It's a balance of power. That's all it is. It's very hard. You want to hire somebody that you know and somebody that, that you've had experiences with, and it's these folks that are arbitrators and mediators that come off the bench or come out of senior partnerships in big law firms. They all know each other. It's a long runway for us, but we can do it.
It's about the people's comfort level, and as Jennifer said, who they know. So let me just add something. If you're really interested in dispute resolution, if I were you, I would follow the New York State Bar Association, because they have a lot of New York State Bar Association has a lot of programs, various aspects on dispute resolution, from implicit bias to representing a client in mediation. And one that's coming up on March 13 is cross-fertilization of best practices recommendations by CONFED. That's the Committee on Federal Litigation.
Commercial Federal.
Yeah, and the dispute resolution section for improving dispute resolution in the courts and in arbitration. So follow State Bar's website for dispute resolution seminars, CLEs, and other educational things.
And we're going to have a program coming up in the fall. It's usually the third Friday in October at New York Law School. It's an all-day event. It is our fall meeting. It's very informative. It's also an opportunity to meet players. Everybody's there, you know, from the folks that are in the court system to AAA and JAMS and NAM, and then the rest, and a bunch of mediators and arbitrators that are there and that are helpful, and be happy to speak to folks about what their career paths have been. And there's a whole world. I mean, there's international, you know, another program could easily be on arbitration for you folks, but there's a whole world of areas for mediation and practice areas. If it's something that you're interested in doing, start your training now and keep going with your training and use it to supplement your practice area and get better and better at it, because it's something that takes a long time to actually get good at. It really does. Nobody walks into the room the first time and it has a home run. You know, you stumble a lot until you get there.
Great. So we are going to continue with doing topics such as this one. And if you all on the call have suggested topics, if you want to know more about sort of the career path and mediation arbitration, if there's specific questions, when you get your survey for this, or if you just like to email me generally, send some ideas and we'll be happy to create some content to respond to your questions. I want to thank Alfreida and Jennifer for their participation, and thank all of you for joining us today. The recording will be circulated to each of you, and it'll also be on our website for folks who are unable to attend. And really quickly, before I get you off the phone, don't forget our upcoming event on Friday is our Masquerade Black Ball. We look forward to you coming there. It'll support scholarships for students, and of course our annual event, which is our gala. And thank you so much. Have a wonderful, wonderful day. We'll all talk soon. Bye.
Thank you, Paula.
Thank you for having us. Bye-bye.
Thank you.